welcome to Moneylife. This is Sucheta Dalal. Today we're going to talk about Franklin Templeton Mutual Fund and the various schemes, 6 debt schemes that it closed down all of a sudden on 23rd April 2020, right in the middle of a pandemic when people were already concerned. About 3 lakh people who had invested in total 26,000 crore were completely shocked to hear that 6 of the schemes are going to shut down. Now, it doesn't mean all that money is going to be lost. A part of it is going to come back. But why does a mutual fund close down a scheme? Obviously, there was panic, there was questions about recovery. So Franklin's trustees decided that 6 schemes will be closed down, no more redemptions, no fresh money coming in, and they're going to sort out and collect the money that had been invested. Now, investors obviously are in a panic. They have been trying all kinds of remedies. The Karnataka High Court judgment is a kind of milestone. It's going to be appealed. Franklin has already gone public to say some aspects of that case will be taken to the Supreme Court. But this case is different and it's interesting, and one needs to know why. So in today's video blog, I'm going to talk about the role of Franklin and its trustees, the role of SEBI, why is this judgment different, and why did this case make a bigger difference than lots of other cases where the mutual fund industry has been up to all kinds of shenanigans and got away with it. Okay, so why is this judgment different? First of all, it's not your routine High Court judgment where somebody files a case and there's a judgment by the High Court. In fact, there were 4 cases filed in different courts. A Gujarat High Court case, a couple of them in the Madras High Court, and there was something in the Delhi High Court. There was an appeal from the Gujarat High Court judgment to the Supreme Court by SEBI and I think it was Franklin Templeton. The Supreme Court decided that it's going to club all these 4 cases together and request the Bangalore High Court Chief Justice, who was former judge of the Bombay High Court, Mr. Abhay Oka, to hear it with a division bench. So it was where investors are concerned, they couldn't have got better than this. It was Justice Abhay Oka who heard it in a division bench in Bangalore. So 4 High Court cases clubbed together in the Bangalore High Court. So it's not just one High Court, it's listening to 4. So you could call it a kind of mezzanine before the Supreme Court, not a regular appeal from the High Court, but 4 of them clubbed together. The case is amazing because it has upheld a few things that Franklin's trustees have done, but it has told Franklin Templeton that it can wind up the 6 debt schemes so long as it gets the consent of the unit holders. Franklin has been arguing all this time that we've already sought the consent. This was hotly debated and argued before the court, and the court said, no, you did not seek the consent on winding up, but you sought unit holders' consent on who will do it and who will take decisions, which is the trustees. So trustees have been empowered. The court has upheld. The case asked for a lot of things, including scrapping of some of the mutual fund regulations themselves. The court hasn't upheld that, but it has said that the consent of the trustees should be sought. Obviously, Franklin doesn't like it. Nobody likes the fact that ordinary unit holders, people like you and me who have invested based on a slogan which says all mutual funds are great, mutual funds sahi hai, sanctioned by the regulator. So don't look at what you do. When your money is lost, they don't want you to have a voice, right? So this is something that the court has said won't do. You will have to seek their concurrence. What is most interesting to me in this judgment is 2 things. What the court has had to say about SEBI. But before I come to SEBI, I'm going to talk about what and why this court case was argued. You know, this was done online. So there were really high-powered lawyers from 4 centers arguing it online before the court. The best and most highly paid lawyers in the country appearing for all the litigants. Interestingly, even the investors were well represented and made a really strong case. There's a reason why this happened, and this is because of the Chennai Financial Markets and Accountability Group. This is an investor association which had legal power to match SEBI and Franklin Templeton and AMFI and all others who were before the court. it made some incisive points. What it did before the case came up or during the hearing was it filed an FIR. When it filed an FIR with the Economic Offences Wing of the Chennai police, action was going to be taken. It created panic in the mutual fund industry, and the Association of Mutual Funds rushed to SEBI and told the regulator, you should act to prevent this happening because it's going to take things off to a different trajectory. Now, the Chennai Association put out press releases, erupted in anger, and frankly, people like us supported what they had to say because they said, who does the Association of Mutual Funds represent? Sure, the mutual fund industry, but their job is to invest our money well. And who are they going to? To the regulator. What is the regulator's job? The preamble of the SEBI Act says investor protection is first. And yet, think about it, the regulator, which never ever interacts in the last decade with investor groups, investor associations, or investors directly, has the ears of AMFI. AMFI can reach them anytime. AMFI can make a noise. AMFI can reach mainstream media and get heard, but not the investors whose money is at risk. In fact, this whole act and SEBI itself has come about to protect investors. This is a point that CFMA, which is the Chennai Financial Markets and Accountability Group, made very, very strongly before the court. The FIR didn't come up for hearing, but they pointed out in numerous ways in which AMFI was behaving like a club, and it was all against the interests of 3 lakh investors who were affected. Now, let's look at what the court has to say about SEBI. And this is quite an eye-opener. So what the Karnataka High Court judgment has done is essentially give a whipping to SEBI and teach it what its role is and what its act says its duty is. This is particularly interesting because the regulator actually went before the court and tried to say, you don't have a jurisdiction, we are a specialized body, fully empowered, very powerful, we've started a forensic audit, we know what's got to be done, so you should not even hear this case. The judgment has not only disregarded all of it, but here's what it has to say. In fact, remember, SEBI is 28 years old, and the judgment has to say, prompt action by SEBI was necessary to sustain the confidence of investors. As the watchdog, SEBI was expected to play a proactive role by questioning the AMC trustees and the sponsor about compliance with provisions of mutual fund regulations. The investors and unit holders of the said schemes will be justified in their criticism that SEBI was a silent spectator. In fact, this is something that all our video blogs have been saying, whether it is a series of broker defaults, whether it is failure of corporate governance, SEBI just gets away by complete silence. We are supposed to believe that it's doing something and it will eventually come up with some kind of punishment, which may be 3-4 years later, which may or may not return investors' money, but you are supposed to file a complaint with scores and keep quiet in the belief that SEBI is going to act for you. Now, we have a judgment which says, no, we have a right to expect a lot more. The court order says SEBI's main obligation is to act as a watchdog to protect the interests of investors, and second, to ensure that trustees and the asset management company strictly abide by the SEBI Act and mutual fund regulation. Why did this have to be spelled out to the regulator? Now, in this particular case, why is it even more egregious that the regulator kept silent? Because as SEBI and Franklin argued before the court, this was the first case in history, the first time ever in the mutual fund industry that 6 companies were going to use the winding up clause. 6 mutual fund schemes were going to use a winding up clause and shut down the schemes. So the court says when you have such a unique situation, something being invoked for the first time, you expect the regulator to be on its toes, to ask questions, to grill people, and to be proactive about even providing answers to investors who are filing a right to information application and asking questions. Instead, SEBI has actually admitted that it didn't know several of the things. For instance, it says SEBI admitted that it had not bothered to ascertain whether there were compliances with subclauses A and B of clause 3 of regulation 39, which requires them to issue a notice, the mutual fund, in 2 national newspapers disclosing the circumstances which led to the closure of the scheme. This was asked by RTI. They asked even about a forensic audit. So SEBI came before the court. First of all, it told the investors, we don't know. We haven't bothered to ask. It also says SEBI did not bother to ascertain whether redemptions and borrowings had absolutely ceased, simply assuming that Franklin would be doing his job. SEBI also had to be ordered to file on record what the findings of the forensic audit were. Now, it says we're doing an audit, keep quiet. This is its message to investors. The court says nothing doing, put it in a sealed envelope and send it to court. Now, the reason why the court order has not taken this on board is because the forensic audit is not complete. But the partially done audit was submitted in a sealed envelope to the Karnataka High Court. The court further noted that SEBI did not even possess a copy of the 23rd April resolution by the Franklin trustees to wind up the 6 schemes. Doesn't it say, it also failed to respond. Now, okay, doesn't stop with how it treated investors. Franklin's trustees apparently wrote to SEBI on 14th April and asked them, sought its guidance on what to do about winding up. SEBI did not even bother to reply to them. Silence has been its weapon, because when it chooses to adjudicate or issue an order, it can act in limbo, pretend as though nothing has happened, and pull up everybody when it may be equally responsible for failure. I think this is really important, because once again it shows when a bunch of investors can make a really strong case. And I've said this before about Anugrah, and I'm saying it again, that when you make a strong case and you go to the regulator, you can get a judgment that makes sense, that pulls up the regulator. There's also a larger lesson here. Have you noticed that today we don't look at the regulator as your first call for getting justice? Filing a complaint in scores and putting up with silence when your hard-earned savings are lost is not the answer. The regulator doesn't seem to get it. The finance ministry, which supervises 5 regulators in the financial sector, don't seem to get it. And investors are not willing to wait their convenience, so they're beginning to go back to the High Court. And the irony is that in 1992, when SEBI became the first financial regulator to be set up as an independent regulator, it was to create a specialized agency, it was to declog the courts, that it was set up not to create big SEBI bhavans and a lot of bureaucracy and certification and regulations and red tape. But that's all that we have today. Red tape, delays, very little action, and after 4 or 5 years of investigation, a little slap on the wrist, and very, very few cases of investors getting back their money because things don't happen quickly. People are at the end of their patience. This is yet another case which shows that joint collective action can make a difference. Thank you.